Good morning and afternoon, everybody. I'd like to welcome you all to today's session, Mastering Labor Law Compliance for 501c organizations. We're a bit tardy this morning, but we are on our way now. My name is Max Smith. I'm with 501c Services. As many of you all know, we provide full service unemployment management programs and other services to about 3,000 nonprofits across the country. Several of our programs include the 501c Agencies Trust, which offers unemployment risk management solutions for nonprofits, and also 501c HR Services, which is a confidential consultation service about HR issues. Many of you on today's webinar are already working with us, and I thank you so much for doing that. I'm going to get some housekeeping out of the way before I turn our program over to Kristen and Joanna from the Poster Compliance Center. Just so you know, today's webinar is being recorded. We will provide you with a copy of that recording after the program. We also have a copy of the slides. If you go down to the Zoom interface under resources, there's two attachments there. One is a copy of the slide deck. Another one is an e-guide talking about poster compliance rules and regulations. So both of those are yours to keep and pass around your organizations. Many of you are also here for HRCI and SHRM credits. We will distribute those after the program is over once we verify attendance. We usually do that 24 to 48 hours following the program. So look for them before you leave work on Friday for the weekend. If you have any questions or concerns, use your question and answers box. Logistic questions, technical questions, we'll get to those, and also content questions. Our speakers will address those as they can throughout the program. So I think I covered all the housekeeping for you guys. I'm going to go ahead and allow Kristen and Joanna to introduce themselves. I want to introduce the Poster Compliance Center, though. Poster Compliance Center is actually a strategic partner of 501c Services. They're the resource that our customers use for labor law posters. So if you are a member of our program, you do get a pretty good discount. I believe it's 31% off of the services and resources of the Poster Compliance Center. I know your next thought is, how do I get that 31% off? Do not fear. I'm actually going to send you an email first thing tomorrow morning that reminds you how to access their services and your discount. So that email will be coming out separately tomorrow morning. So you'll probably get two emails from us. You'll get HR certification, and you'll also get information about the services that Poster Compliance Center provides 501 customers and members. Okay, I think I covered it all, ladies. I think you guys can go ahead and take over and do what everybody's here to see is your program.
Awesome. Yeah, thanks, Mac. We appreciate you having us today. Hello, everyone. Thank you for tuning in. I am Jo, the Marketing Director here at Poster Compliance Center. I'll be providing an introduction to today's webinar, offering some insights into our company, and assisting with the Q&A at the end. Leading this discussion today, we have Kristen. Kristen is an entrepreneur with a wealth of legal expertise. She spent nearly a decade practicing employment law at a prestigious firm in a Fortune 200 company. Tackling all sides of HR-related legal and compliance issues, her unique experience gives her a deep understanding of both the law and the practical application for your organization. With Kristen's guidance, we're confident you're going to gain valuable insights and practical tools to ensure your nonprofit thrives with a strong foundation in labor law compliance. As a trusted partner for organizations of all sizes, Poster Compliance Center understands the unique challenges faced by nonprofits in navigating labor law complexities. Since 1991, our company has offered compliance management services for a wide array of industries and organizations of all sizes. We use the highest level of care and attention to detail to research the latest city, state, and federal requirements. Today, we're going to share best practices, highlight the importance of compliance, and explore some creative strategies to keep your organization informed and compliant. It's important to note that while we do strive to provide accurate and up-to-date information on labor laws, employment law is complex and can vary by location. We recommend consulting an attorney for specific legal guidance regarding your organization's unique circumstances. I think that's it for me. So let's go ahead and get started. Kristen, I'll pass it over to you.
Good morning, everyone, and thanks for joining us today. I'm on the East Coast, so good afternoon to those of you joining us from there. And where I want to start today is talking about why it matters to comply with employment laws. It's crucial for any organization to comply, including nonprofits. So I'm going to walk you through 6 reasons that compliance is so important. The first is protecting workers. Labor laws are designed primarily to protect workers' rights and to ensure fair treatment in the workplace. This includes safeguarding against exploitation, discrimination, and unsafe working conditions. By adhering to labor laws, organizations demonstrate a commitment to the well-being of their employees, which is foundational to a healthy and productive work environment. Next, promoting fairness and equality. Labor laws promote fairness and equality by ensuring that all employees are treated equally, regardless of their race, gender, age, disability, or a bunch of other protected characteristics. This helps create an inclusive workplace where diversity is valued and all employees have equal opportunity to succeed. Third, improving worker engagement. When workers know that their rights are protected and that they are being treated fairly, their engagement and morale are significantly higher. Engaged employees are shown to be more productive, more committed to their work, and more likely to stay with your organization. This is particularly important for nonprofits, which often rely on dedicated staff to achieve their mission. Next, ensuring safe working conditions. Labor laws include provisions for workplace safety, such as those outlined in the Occupational Safety and Health Act. These regulations ensure that employers provide safe and healthy working conditions and prevent workplace accidents and illnesses. A safe workplace not only protects you or your employees, but it also reduces the risk of costly lawsuits, regulatory investigations, and workers' compensation claims. Also, labor law compliance helps strengthen economic security. Laws such as the Fair Labor Standards Act establish minimum wage and overtime pay standards that help improve workers' economic security. By ensuring that employees are paid fairly for their work, these laws help reduce poverty and promote financial stability, which benefits not only your workers, but also the economy as a whole. Next, avoiding legal fines and penalties. Non-compliance can result in significant cost for your company in terms of penalties. These penalties can be financially devastating for your organization, especially if your organization has a tight budget. And just beyond financial costs, legal issues can also damage your reputation, erode trust among your donors and stakeholders, and divert resources away from your mission critical activities. By understanding and adhering to the labor laws, your organization can create a fair, safe, and productive work environment and overall contribute to your success and sustainability. It's all about building a more responsible and ethical organization that values and protects your employees. So what's special about nonprofits when it comes to compliance? Absolutely nothing. You should follow the law just like any other employer. But there are a lot of myths out there about what really applies for a nonprofit. But the myth that you don't have to comply with labor laws is just that, and we're going to debunk it today. You are not, as a nonprofit, treated differently compared to a for-profit organization. You are not treated differently in any way, shape, or form. You're not exempt. So you must adhere to the same rules and regulations as every other employer. And if you misunderstand your obligations, you're subject to a legal claim or penalty just like anybody else. So a couple of other myths that may exist. You're not exempt from the labor law just because you operate for the public good. Regardless of your mission-driven work and your charitable status, you still must comply with all federal, state, and local labor laws that apply to your organization. That includes minimum wage, overtime, employee classification, workplace safety, and anti-discrimination. Additionally, another myth that we often hear is that volunteers can be treated just like employees without adhering to labor laws. Well, that's not true. while volunteers are not employees, you still have to follow some guidelines about how you use them, or they could be classified as employees, and then you may have to end up paying them wages or benefits. Misclassifying your volunteers can result in significant penalties and back wages. Another myth: smaller nonprofits with limited budgets have more leeway in compliance. Your budget has no bearing on whether the law applies to you. All nonprofits, from the smallest to the largest, must ensure you are fully compliant with law. In many cases, the size of your organization isn't going to affect your obligations. For example, the Occupational Safety and Health Act will apply to you regardless of how many employees you have. At the same time, there are other laws that have more requirements. The Fair Labor Standards Act applies to every employer with at least 2 employees. However, there are other laws that have a threshold of 15, sometimes 50 or 100 employees, and we'll walk through those in a few minutes. But think about this: even if you are exempt from the law because of a size requirement, think about the message it sends if you choose to not follow the law that applies to every other employer. You'll no longer be an employer of choice because other people will be compliant with the law, and that word will get around. So let's take a closer look at some other reasons that nonprofits should comply with labor laws. It's important for nonprofits to comply because it's just the right thing to do, and it helps to avoid legal trouble. So let's talk about that legal trouble for a second. Fines, penalties, and lawsuits are more likely to happen the more often you don't comply. Legal actions can result in significant costs that can ruin your budget. They're also going to divert valuable resources away from your mission and damage your ability to serve the community. It also ensures that you have ethical and responsible use of your funds when you comply with the law. Donors trust that your contributions will be used ethically and responsibly. Compliance ensures that you use funds to support things like fair wages, safe working conditions, and equitable treatment of employees. This aligns with the ethical standards that donors expect and helps maintain donors' trust and support. Next, your reputation is one of your most valuable assets. Adhering to labor law helps protect your reputation by demonstrating your commitment to legal and ethical standards. When you treat employees fairly and legally, it fosters a positive organizational culture and enhances public trust in your operations. Fourth, it reflects integrity and accountability. Nonprofits are often held to higher standards of integrity and accountability due to their mission-driven nature. Compliance with labor laws reflects a nonprofit's commitment to these values. It shows that the organization is accountable to employees, donors, beneficiaries, and the broader community. This integrity is crucial for building long-term relationships and securing ongoing support. Finally, most nonprofits like yours are founded on the principles of fairness, justice, and service to your community. Compliance with labor laws is consistent with all of these values. Treating employees fairly, providing safe working conditions, and ensuring non-discriminatory practices all align with the ethical and moral obligations that guide nonprofits. This alignment strengthens your mission and reinforces your credibility. So let's take a look at what the major labor laws that apply are. Here's a list of what we're going to cover today: the FLSA, FMLA, ADA, Title VII, ADEA, OSH, NLRA, USERRA, and the WARN Act, and GINA. So understanding and complying with this alphabet soup of labor laws is critically important for all businesses, including nonprofits. Compliance ensures legal protection and fosters a fair, safe, and equitable workplace. So let's walk through these one by one. First, the Fair Labor Standards Act. The FLSA establishes minimum wage, overtime pay, record keeping, and child labor standards for employees in the private sector and in federal, state, and local government. For nonprofits, this law requires you to ensure that all non-exempt employees are paid at least the federal minimum wage and receive overtime pay for all hours worked more than 40 in a work week. It's essential to keep accurate records to demonstrate compliance with this law. This law requires compliance with by all companies with at least 2 employees who either have one of the following: $500,000 in revenue, and before you get too excited about that threshold, or if you're engaged in interstate commerce. Now, if you're a smaller nonprofit, you may think that doesn't apply to you. But interstate commerce has been defined by the courts really broadly. So if you have ever done something like send a letter through your nonprofit through the mail to somebody in a different state, that counts as interstate commerce. So basically, the FLSA applies to almost all nonprofits. Next, the Family and Medical Leave Act, the FMLA. This law entitles eligible employees to take unpaid job protected leave for specified family and medical reasons, with continuation of group health insurance coverage under the same terms and conditions as if they had never taken that leave. The key here for nonprofits is to understand who is eligible and ensure that they say yes to the appropriate leave when required. The FMLA will apply to you if you have more than 50 or more employees in a 75-mile radius within your company. And employee eligibility is based on having worked for you for at least 12 months and having at least 1,250 hours of service in the last 12 months. Next, the ADA, Americans with Disabilities Act. The ADA prohibits discrimination against individuals with disabilities in all areas of public life. One of the areas carved out by this law is employment. So nonprofits must ensure that your employment practices, including hiring, promotions, and accommodations, all comply with the ADA standards. The goal is to create an inclusive workplace that allows individuals with disabilities to fully participate in their job. This law will apply to you if you have 15 or more employees. Title VII, and with Title VII, the Age Discrimination in Employment Act, the ADEA. The federal law, Title VII, prohibits employment discrimination based on protected categories that include race, color, religion, sex, and national origin. The ADEA adds protection against discrimination based on age for anyone who is 40 years old or older. The key here is to ensure that your practices are free from discrimination, whether you intend that discrimination or not, and foster an environment of equal opportunity. If you're an employer with 15 or more employees, Title VII applies. And if you have 20 or more employees, you're subject to the ADEA. Next, the Occupational Safety and Health Act. The OSH Act ensures safe and healthful working conditions by setting and enforcing standards and providing outreach, training, education, and assistance. Nonprofits are required under this law to provide a safe workplace, which means you have to identify and mitigate hazards, provide necessary training, and follow OSHA regulations. This law applies to all employers, regardless of size. The National Labor Relations Act. This law protects an employee's right to organize, bargain collectively, and engage in other concerted activities for mutual aid or protection. This law requires you to respect an employee's right to form a union and to participate in collective bargaining without fear of retaliation. Something as simple as posting on social media has been defined as collective bargaining. So just keep that in mind. The NLRA will apply to you regardless of your size of your nonprofit, but it will depend on your revenue. So for a health-related organization, for example, like a hospital or a nursing home, you must have a gross annual volume of business of at least 250,000 for this law to apply. Other nonprofits like social services organizations, schools, you must have an inflow or outflow of goods of at least $50,000 in interstate commerce for it to apply. The seventh law on our list is USERRA, the Uniformed Services Employment and Reemployment Rights Act. USERRA protects armed services members' reemployment rights when they return from serving in the Army, the National Guard, or the Reserves, the Navy, any form of branch of service. And it prohibits employment discrimination based on past, present, and even future military service. So what it will require nonprofits to do is ensure compliance by accommodating service members when they return and returning them to their prior job if they meet certain requirements. And this law applies to all nonprofits. The WARN Act, the Worker Adjustment and Retraining Notification Act. This law requires employers to provide notice of 60 days if they close a plant or have a mass layoff. If you're a larger nonprofit with 100 or more employees, you are going to have to provide this notice to avoid penalties under the law. It's the right thing to do under the law to prepare employees for the transition outside the workplace. Next and last, the Genetic Information Non-Discrimination Act, GINA. GINA prohibits discrimination on the basis of genetic information in both employment and health insurance. For nonprofits, that means you must not use genetic information in making any employment decisions, including hiring, firing, or promotions. This law applies to 15 employers with 15 or more employees. Those are the basic federal laws that apply to most nonprofits. But just to add another layer of complication, we also have variations on these laws at the state and local level. So a lot of state and local laws will vary depending on minimum wage requirements. If we can go to the next slide, please. Thank you. Meal and rest breaks, paid sick leave, pregnancy leave, and additional protected categories. So I'm going to walk you through some examples of this using California. And I think many of you in this call are from states like California that have extra requirements. So for example, in California, California has one of the highest minimum wages in the country. As of this year, on January 1st, 2024, the minimum wage is $16 an hour for all employers. Some California cities and counties, like San Francisco and Los Angeles, have even higher minimum wages. In just a few weeks, on July 1st, the minimum wage in Los Angeles is rising to $17.28 an hour. And on July 1st in San Francisco, the minimum wage will jump to $18.67. And in terms of overtime, California is also a bit of an outlier. In addition to what the federal law requires, which means more than 40 hours in a week entitle an employee to overtime pay, the overtime pay in California is also for any hours worked more than 8 in one day. If an employee works more than 12 hours in a day, the employer has to pay double time for those extra hours. Or if they exceed 8 hours in the 7th day of work in 1 week, they also have to pay double time for that too. Same thing is true for meal and rest breaks in California. California law gives employees specific time for meals and rests. So during a 5-hour or more workday, employees are entitled to an unpaid meal break of 30 minutes. If they work more than 10 hours in a day, they get a second 30-minute break. Plus, these employees are entitled to a 10-minute rest break that's paid for every 4 hours they work. The idea is to ensure that employees are not overworked and they have adequate time to rest and recharge. California also offers paid sick leave. The paid sick leave law, called the Healthy Workplaces, Healthy Families Act, requires employers to pay sick leave to their employees 1 hour for every 30 hours they work. Employees can start accruing their sick leave based on the 90th day they're employed with a company. Next, pregnancy disability leave. California law offers specific protections for employees who are disabled because of pregnancy or related conditions. If you are an employer with 5 or more employees in California, you have to provide up to 4 months of unpaid job protected leave. This leave can be taken intermittently, or employees can choose to spread it out over a reduced work schedule. And finally, thinking about protected categories. California and many other states have expanded protections beyond what the federal law allows. So in federal law, we have race, color, religion, sex, national origin, age, disability, and genetic information. California law adds sexual orientation, gender identity, gender expression, marital status, medical condition, military or veteran status, and even ancestry. So more states are adding laws like this, so you need to be aware of what is applying to your organization in your particular area. So once you've determined what laws apply to you, it's time to figure out how to best comply. And we've put together a list of 7 different ways that you can focus on increasing the compliance in your organization and avoiding some of these problems. The first is the basic one, establishing policies. Clear, comprehensive policies should outline your commitment to adhering to labor law. These policies need to cover all relevant aspects of employment, from hiring to wage and hour standards, anti-discrimination, entitlement to leave, workplace safety, and discipline. Documenting your policies helps provide a couple of different things. And one of the most important is a consistent framework for decision-making, but it also ensures that all employees understand their rights and their responsibilities. And it also helps you in the event of a claim or a lawsuit. You can point to your policy and show that you are taking your obligations seriously. You should also have an employee handbook. A handbook consolidates all of your policies in one accessible document. Whenever you hire someone new, you should make sure your employee gets a copy of these policies so you can say they know about the policies. It also serves as a guide for you to make sure that you are consistently applying your policies to all employees. The next step is to provide training. Ongoing education and training are critically important, especially if you have employees in managerial and supervisory roles. What your training should cover includes all kinds of labor laws, anti-discrimination, wage and hour, your leave policies, and workplace safety. Training sessions that you conduct regularly on these topics reinforce the importance of compliance and keep employees aware of their own responsibilities as well as their rights. To make training more effective, we recommend using interactive and engaging methods, workshops, seminars, e-learning modules, and scenario-based training. Make it more interactive for employees. It helps them understand the information better and retain it, and makes it more likely that they'll apply it in their daily jobs. We also recommend that you include training in your new employee orientation program. This ensures that hires understand your commitment to compliance from the start and are aware of the policies and procedures that govern their employment. If you have a cadre of managers and supervisors, you should consider having a specialized training for them that reinforces the importance of their responsibilities. You'll need to make sure they know how to handle employee complaints, complete performance evaluations fairly, and maintain a safe working environment. If you give them the skills and knowledge they need, they'll be able to help you stay in compliance. One thing that a lot of companies are not as good about is record keeping. One area of record keeping that really matters is keeping a detailed record of all of the training sessions you hold, who came, what you covered, and what materials you used. All of this documentation can be critically important if you need to demonstrate that you're compliant, and if you have an audit or legal inquiry, they can be a lifesaver for your organization. The last thing I'll leave you with on this section is making sure that you create an environment where your employees feel comfortable asking questions and raising concerns. If you have that kind of open door policy where people feel comfortable reporting potential compliance issues, you can prevent a lot of problems down the road. Next, be proactive. Keep in mind that labor law is not a static thing. Every year, states and localities enact new legislation, new court rulings come out, and administrative agencies may change policies. It's important to stay ahead. So keep informed about potential changes at the federal, state, and local levels. Labor law organizations like PCC offer regular updates on these laws. You may also be able to attend a workshop. A lot of organizations offer workshops online, much like this one, or consult with your legal expert or HR who might have more specialized knowledge about employment law. With this knowledge in hand, do an audit of your organization. Review your practices and policies to ensure they align with current legal requirements. For example, you may want to assess your wage and hour practices to make sure you're complying with minimum wage and overtime regulations. One of the most important things I ever did with a retailer I worked for was going to their organization and spending hours poring over their wage and hour records in California. We were able to identify that we were not regularly giving people their entitled meal breaks and rest breaks. And that led to a huge change in our policies and practices. So I highly encourage you to audit. You could also engage with your employees. I would recommend connecting a survey, a focus group, or a town hall meeting to gather that feedback and really create that open door atmosphere. The more proactive you can be about addressing employee concerns, the earlier you can get ahead of compliance issues and avoid them from turning into a lawsuit. One thing that might be helpful in this regard is creating a compliance calendar. Your calendar should include key dates and deadlines for all compliance-related activities. That might include filing requirements, the dates of training sessions, scheduled policy reviews, and schedules for your audit. Keeping a regular calendar ensures that critical tasks are not overlooked and that you complete them on time. If you're a larger organization, maybe appoint somebody to be responsible for this process. You may benefit from having a compliance committee or a compliance officer who can oversee your compliance efforts. They should be responsible for monitoring compliance, staying updated on changes, and ensuring that all of your policies reflect current labor law. Next, audits. I mentioned a little bit of this before, but internal audits are critical. Look at wage and hour practices, your classifications of your employees and volunteers, your safety policies, what you do to support anti-discrimination, and how you are allocating employee leave. If you look at these regularly, you can identify the potential issues and address them before they escalate. If you're a large enough organization, you may want to hire a third-party expert to conduct this audit. An auditor external to your company can provide an objective assessment of whether your nonprofit is adhering to the law and look for opportunities to improve. This is especially important to do if you know that you have a regulatory audit coming up or if you've gotten a complaint. Again, a checklist here with the audit process is incredibly important. You might include in your checklist a list of all the legal requirements that apply and also make a list of the best practices. So for example, a wage and hour checklist might ensure that you have classified all of your employees correctly, check for all of your accurate timekeeping records, and making sure that all employees are paid overtime correctly. With every audit you do, document your findings. If you include areas of non-compliance, you should also include how you've corrected those problems. Documentation will give you a clear record that you are making an effort to be compliant with labor law, and they are effective due diligence evidence as well. Audits are an important part of a continuous improvement process. So as you go along, you may want to update your audit process. The more intense your audit process, the more regularly you audit, the more you'll create a culture of compliance. And you'll show employees at every level of your nonprofit that you understand the importance of adherence with labor law and making a compliant workplace. Fifth, accurate record keeping. Accurate records are the cornerstone of compliance. Good record keeping ensures you demonstrate compliance and helps protect your organization. So what kinds of records should you maintain? Employee information, basic things like personal details, job titles, employment dates. And one other note on this, make sure you keep this information on a need-to-know basis. Not everybody in your company should have access to personal employee information. Next, wage and hour records, hours worked, wages paid, overtime hours, any deductions you make. You'll want to use these records for FLSA compliance, as well as compliance with state and local law. Leave records. You should document every instance of a leave taken by employee, whether that is under the Family and Medical Leave Act, state leave, sick leave, vacation, or any other kind of leave. You can not only improve your management of employee absence that way, but you can also show that you're complying with leave laws. Training records, as we mentioned before, documenting the training that you run is essential for showing compliance. Some state laws require you to document your training, California being one of them. So maintaining that compliance means that you need to keep accurate records. And finally, performance and disciplinary records. A lot of times companies do not memorialize oral conversations they have with employees. It is vitally important to record everything that you have as far as performance evaluations, disciplinary actions, and any kind of other incidents that involve misconduct. All of that can be critically important down the line if an employee files a dispute. A few things just to note on the record keeping front. Digital systems make it really easy for record keeping. Make sure that they are secure and make sure they're backed up just to prevent loss. If you end up losing employment records, digital records, that can look really bad in a lawsuit. You can be a claim of spoliation of evidence, which just means loss of evidence, can be filed against you, and it can lead up hurting your appearance before a jury or a judge. Regular updates to policies and documentation. Make sure your records reflect that you are changing your pay, for example, in response to new minimum wage. Make sure you recorded the dates when you have made those changes so you can go back and show compliance later on. Finally, retention periods. A lot of people like to clear the decks, get rid of all of their documents, their paper, but that doesn't work in a lot of cases because you must keep certain records under the federal and state laws. For example, the Fair Labor Standards Act requires you to keep your paperwork for at least 3 years, and your payroll records need to be kept for at least 7. So before you discard your employment-related records, make sure you've got clearance. And if you don't have a records retention schedule, I highly suggest that you make one. And make sure that all of your digital records are subject to that schedule as well. 6th, addressing complaints. As we mentioned before, an open door is necessary. Make sure your employees are comfortable reporting their concerns and complaints. Ensure your employees that their complaints will be taken seriously, and keep all of those complaints confidential. If you don't have a hotline in your company for this, make sure you have a designated person who can handle these complaints. That should be part and parcel of whatever procedure you establish. So you should establish multiple channels, ideally, whether that's your HR contact, the anonymous hotline, an online reporting system, or a supervisor. Make sure employees know where they can go, how to use them, and make sure your supervisors and other employees know how to handle them as well. Whenever you get a complaint, make sure you handle it promptly and thoroughly. You may need to assign a neutral party, such as somebody from HR or an external investigator, to make sure the investigation is handled properly. And as always, make sure that you document all of the information you gather and all of the steps you take. With any complaint you receive, make sure you address it fairly and impartially. If you have disciplinary action that you take, document that. You may need to change a workplace policy if things have gone awry, or you may need to implement some additional training. Make sure you communicate the outcome of whatever you decide to the person who complained, and take steps to prevent it from occurring again. Of course, you should also have a non-retaliation policy. Employees who complain need to know that they will not be discriminated against or retaliated against for complaining. If you notice this in your workplace, make sure any sort of retaliation is addressed immediately, and make sure that all employees know that you will take it seriously. Finally, seeking guidance from HR and compliance professionals and legal counsel. Labor laws are complex, and moreover, they change frequently. HR and compliance professionals, plus legal counsel, can offer valuable insights and assistance in interpreting and applying the laws. Keep in mind that your HR and compliance professional is your first line of defense, just in case something happens. So make sure that your contacts, your HR professional, your compliance professional knows the federal and state labor laws and is aware of any changes. If you don't have that within your organization, identify legal counsel who can help. Legal counsel specialize often in helping nonprofits, and they can help interpret specific requirements for your organization. They can also help you review your policies and ensure that you have the right protections in place. And if something does go awry, they'll already have legal counsel in place ready to help you. Finally, specialized compliance firms can also serve as a valuable resource. They can assess your compliance efforts and suggest additional resources and support. Now, we talked about what you can do on the employer side. So what can you do to help your employees? The first we're going to cover is labor law posters. One of the most common ways to inform employees about their rights is through labor law posters. These posters are required by federal and state regulations, and their goal is to summarize key provisions of labor laws. The key here is to put them in the right place. You have to put them in a place where employees can actually see them. A break room is a common place. These labor laws also need to be kept up to date. So these labor laws change periodically, just as the laws do. So you want to make sure that whatever is on your wall or in your digital workplace, which we'll talk about in a second, is just as compliant as everything else in your organization. Employee handbooks, we've mentioned these before. Your handbook should contain all of your up-to-date policies and procedures. If you change your policy, you need to immediately update your handbook. So make sure you have covered everything and kept it current in your handbook. Training and e-learning. Training and e-learning sessions are great ways to keep employees aware of labor laws. You can cover anti-discrimination, workplace safety, wage and hour compliance. Regular training should be a part of your cadence every year. So again, offering that specialized training for managers and supervisors once a year, regular training for employees once a year is really a best practice. If you offer e-learning, it's a great way to allow employees to complete the training at their own pace. And you can also incorporate interactive elements to improve their learning. Those were some of the more basic ways to keep employees informed. But some of the more creative and modern methods include digital platforms. If you have an intranet or an employee portal, even a mobile app, you can use those to disseminate information about labor laws. If you have a Slack channel, you can create a section where you talk about the resources and articles available to employees. Any kind of digital platform makes it really convenient and easy for you to give employees anytime, anywhere access to the resources they need. You can also change up your traditional training with interactive workshops and case studies. Give employees a chance to role play. Allow them to be part of a group discussion. Using real life scenarios illustrates how labor laws apply in different situations and helps employees learn how to problem solve. It also improves engagement with and deeper understanding of basic labor law concepts. Newsletters, social media, and employee recognition programs also help employees engage more with your compliance tools. So regular newsletters and bulletins that highlight updates, success stories from in your company, and employee spotlights can really show how we're focusing on creating a culture of compliance in your organization. You may also want to include some practical tips or resources to help employees navigate labor law issues. Additionally, you can put bite-sized information about labor laws on your social media. For example, you might want to put an update, an infographic, or a link to an important article or resource. If you encourage your employees to follow the official company accounts, you can get them more engaged with your labor law content. Finally, if you have employees or teams who are incredibly exemplary with their compliance with the labor law, if they report a safety hazard, if they're doing something to promote diversity or inclusion, or if they're doing something unusual with training, you can recognize those employees. That will incentivize even more employees to prioritize compliance and continue to improve your workplace culture. The keys with all of the forms of notifying employees are making sure they're accessible. Make sure everybody has access. If you have employees who speak multiple languages, you need to make sure your posters and handbooks are available in those languages, for example. Understanding. The labor laws can be really complex. The goal is to simplify the language and the concepts so everybody can understand. Make sure your posters and handbooks and training use simple terms and clear and concise language. Again, making sure employees have updates is critical. Those updates can be disseminated through posters, emails, staff meetings, social media, just making sure that people are aware in real time of updated requirements. Finally, two-way communication and feedback really matters. So make sure employees feel comfortable asking those questions, sharing their experiences, and contributing ideas for improving your culture of compliance. So next, updating upcoming labor law changes. There are a host of changes afoot in labor law. I'm just going to cover a few highlights. So for example, paid leave policies, including sick leave, family leave, and parental leave, have been really gaining momentum across the country. Currently, there are 13 states with these laws. We talked about California, but there's also Colorado, Connecticut, Delaware, Maine, Massachusetts, Maryland, Minnesota, New Jersey, New York, Oregon, Rhode Island, and Washington State, not to mention Washington, D.C. So make sure you're keeping an eye on the legislative activity in your state because other states have proposed these laws too. And make sure that you are prepared to adjust your policies and practices accordingly. There are new regulations coming out in about a week for the Pregnant Workers Fairness Act. This law is designed to protect pregnant employees from discrimination and ensure they receive reasonable accommodations in the workplace. So as of June 18th, 2024, these regulations will go into effect. So if you have 15 or more employees, you may be required to provide some of these reasonable accommodations. So if your employees are pregnant or have a complication related to childbirth or a related medical condition, you need to provide an accommodation unless it creates an undue hardship for you in case it is very difficult, very costly to you. So for example, a reasonable accommodation might be an additional break to drink water, eat, or use the bathroom, a stool to sit on while working, time off for healthcare appointments, reassignment to a different job, telework, or a bunch of other things. Cannabis use. Cannabis has been legalized for use in an increasing number of states. Right now, 24 states permit the recreational use of marijuana. And as these laws continue to evolve, you might need to think about how they affect your hiring policies, your drug testing policies, and any drug-free workplace policies you have. It's key to think about this to ensure you maintain a safe and productive environment while complying with these new laws. New overtime rules also go into effect on July 1st. Starting next month, if you have salaried workers who earn less than $43,888, they will now be eligible for overtime pay. And next year on January 1st, employees who earn less than $58,656 will also be eligible. And the government has said they're going to reevaluate this threshold at least every 3 years. So earlier we talked about employee classification. It is particularly difficult to determine who is and is not an employee in certain organizations. And the key is to remember the IRS test. The IRS test is a control test. So it evaluates three main factors: behavioral controls, financial controls, and the relationship that you have with the worker. So, for example, do you have the right to control what your employee does and how they do their job? Are the business aspects of the employee's job controlled by you? So how you pay your workers, whether you reimburse them for expenses, whether you provide tools and supplies, and whether you have a written contract goes into the type of relationship. Do you have written documents like an agreement or an employee benefit? What will happen if the employee leaves the company? All of those things are factors that may play into whether your volunteers are considered employees or your contractors are considered employees. So be very, very careful on that front. And with that, that's all I have for today. Joanna, I think we're ready for questions.
Awesome. We got some good ones here. So a few of them I did answer in the chat, and then a couple we're going to go ahead and answer. So this is from Michelle. She'd like to know if it's acceptable to have the employee handbook digital only, or are they required to provide hard copies?
Yep. So digital copy is just fine. There's no federal law that requires you to have an employee handbook. And I don't know what state you're operating in, but typically I would suggest two things. You know, if you are a small employer who can't afford to update all the time, your paper copy, digital is just fine, right? But at the same time, I would encourage you to think about the value of having a paper copy, because if you have, I don't want to classify myself as old, but I'm going to, an older dinosaur like me who likes paper, I'm more likely to look at it on paper and absorb what is on the paper than scan through an online document and understand all of those things. So I think you can cover your bases by providing a hard copy initially, and then sending out emails if you update the digital copy with a link to your digital version. That would be my advice.
Yeah, great advice, Kristen. For minimum wage and meal breaks, does that apply to salary as well as hourly?
No, that is a great clarification. Meal breaks and those kinds of things apply for hourly employees. So for example, in California, you need to give those to your rank and file employees. That is a great distinction.
Great. Let's see, this one comes from Dean. What makes an exempt and non-exempt employee?
Right, so we talked about this a little bit at the end. So I'm looking at the question, small nonprofits don't have enough employees for employees to manage 2 or more. So a lot of it comes down to the responsibilities that your employees have and also the salary that you're paying them. So if you are paying employees more than that threshold amount, you have a very good chance that you're not going to have them be considered non-exempt or exempt for the employment purposes. But again, a lot of it comes down to how you assign the employee work, what kind of work they're doing. Are they administrative employees? That kind of thing. There's a whole test. And Joanna, I don't know if we can put this out somehow, but there's a link that I can send to the inquiry. The Department of Labor has a great website where you can run through a checklist and determine whether your employee is exempt or non-exempt.
Awesome. Great. Yeah, if you want to send that over, we could definitely get that to Mac, and he can send it out in tomorrow's email.
Right.
I know we're getting tight on time, so I do want to make sure we can get to the key takeaways because I do think that's important. Let's go ahead and move on to the key takeaways. Great. So again, Kristen, thank you. That was a really great session. We appreciate you being here today and sharing your expertise with us. So now that we have explored the importance of labor law compliance and the key areas to focus on, let's go ahead and summarize the key takeaways to ensure you leave with actionable steps. Compliance matters. Understanding and adhering to labor laws is crucial for nonprofits to protect workers. Nonprofits must comply. Nonprofits are not exempt from labor law requirements. Key labor laws. Nonprofits should be familiar with the major key federal labor laws. Nonprofits operating in multiple states need to be aware of local variations such as different minimum wage rates, leave entitlements, and protected categories, and adjust your practices accordingly. Best practices for compliance: establishing policies, providing training, being proactive, conducting audits, maintaining accurate records, addressing complaints, and seeking guidance from HR, compliance professionals, and legal counsel are critical for effective labor law compliance. And lastly, it's important to inform your employees. Just like Kristen said, there are a variety of methods, including labor law posters, employee handbooks, training, digital platforms, newsletters, social media, and recognition programs that can help you inform and engage your employees about labor laws. This slide outlines the essential points to remember as you navigate labor law compliance for your nonprofit. For ongoing reference, we have provided that e-guide, which should be in the Q&A, I think. Evan had put it there earlier, so make sure you slide all the way up. If not, I know Mac's going to go ahead and send out everything tomorrow. If you have had questions on that. To stay informed of labor law, feel free to scan the QR code on the corner left of your screen. That can sign you up for free labor law alerts by state. So we'd love to have you on that list. Here at PCC, we are committed to partnering with organizations like yours. We offer a variety of services to help you navigate the complexities of HR and compliance. To learn more about how we can help your organization, please visit our website at postercompliance.com or contact us directly at 1-800-322-3636. We hope you found this session informative. Thank you so much for coming. Have a great day.